Well, we've received representations from the community about the fact that there is no law that regulates surrogacy arrangements, and we have listened to those representations. And we actually agree that there is a gap in the law in that there is no arrangement by which surrogacy arrangements are recognized by our courts. And really, if you think about it, if a couple can't conceive, then I'm sure that you will agree with me that it's right and fair that the law permits surrogacy arrangements so that the intended parents can, with a woman who will become the surrogate mother, come into a non-commercial agreement so that the woman agrees for the genetic material of one or both of the parents to be inserted so that the surrogate mother can carry the baby to term, and then for there to be a transfer of that baby to the intended parents.
In what circumstances will surrogacy be allowed?
Well, in the same circumstances as with IVF. It would have to be a couple that cannot conceive and that decide that surrogacy is the only option for them. An important point to make, though, Christina, is that the law does not deal with the clinical and scientific aspects of providing surrogacy in Gibraltar. Parents who decide that surrogacy is an option for them will have to go to the UK or to Spain for the insertion of the genetic material. So the law, to be clear, only covers the process by which a surrogacy arrangement is recognized by the courts so that the parents become the parents of the child.
Would these procedures be supported by the GHA?
Well, currently the law simply is for the recognition by the courts of the surrogacy process, and for that eventually there is a court order that provides that the intended parents have become the parents of the baby. Whether those arrangements will be funded by the GHA, like with IVF, for example, is a matter that is very much alive. It is not a provision that is made for in the current budget, and of course, because it engages the public purse, any policy that the GHA board decides to pass to fund surrogacy arrangements will have to be put to cabinet in due course. But it's not something that the GHA is averse to doing, but is something that is being actively considered and on which a decision has not yet been made.
One thing this criminalises is surrogacy for money. Has this been prompted by any such cases here in Gibraltar?
Well, remember that right now, currently, if you and I were to enter into a surrogacy arrangement, that arrangement would have no legal effect because there is no law that recognises such an arrangement. So, in effect, that arrangement would have no legal validity. So there has, in fact, not been any cases of which I am aware that have brought these concerns. The law that we have published, the bill that we have published, is based broadly on the UK Act. And the reason why we've done that is not because we tend to just cut and paste what is provided for in the UK, but because on the whole, on balance, the arrangement seems to be working well. But we took the policy decision from the very beginning that we would not countenance commercial arrangements, i.e. a couple telling a woman, we will pay you to pluck a figure completely out of the air, £50,000 for you to have our baby. So what the law does is that it expressly prohibits commercial arrangements for surrogacy. As you rightly say, that sort of arrangement is criminalised, but of course, naturally, I think, the law allows for the reasonable expenses of the surrogate mother to be able to take the baby to term for the intended parents to be able to pay for such expense. I think that is right and proper.
Surrogacy is, of course, aimed at couples who can't have children, such as those with infertility issues and same-sex couples.
Yes, that's right. IVF, as you may recall, my colleague and predecessor, John Cortes, announced at the time, in fact, I think it was just slightly before there was a reshuffle, that IVF would be extended to same-sex couples. Of course, you and I realize that it can only be same-sex women who can be offered IVF because one or one of them will be able to be inseminated with genetic material and carry a baby to term. That is not something that can be offered to same-sex couples that are men, because, of course, to state the obvious, they don't have wombs. And so the government was very much of the view that on the basis that we are providing IVF to same-sex couples who are women, we felt that same-sex couples who are men also have the same right to be able to have children. And surrogacy is one of those options, and I think that Canada has had surrogacy arrangements for decades now, and it is something that has been proven in other common law jurisdictions to work. And of course, you and I are talking about the bill, which will become an act, and whether the GHA will pay and what amount it will pay. But the truth is that this policy is the sort of policy that I think can be transformational to couples, because they will go from a situation where they cannot have children to being able to have children. And I can't imagine of something more important for couples who cannot have children than to have the option and the ability to have a child and to start a family.
One potentially contentious issue is if the surrogate mother decides she wants to keep the child after all. So how does this bill define the respective rights of the surrogate and the parents with respect to the child?
Well, as you know, the law has to draw the line somewhere. So the way that the bill is phrased is for the application to be made by the intended parents once the child is born, and then the surrogate mother has to consent for the surrogacy arrangement to be fulfilled. It is entirely conceivable, although in my opinion unlikely, that a surrogate mother could, at the very end of the process, decide that she does not want to go through the surrogacy arrangement. But you really have to ask yourself how likely that is going to be when a surrogate mother has put herself through the process of allowing for the insertion of the genetic material that has allowed for basically her body to allow a baby to be taken to term, and with all of the costs that will entail for her to change her mind. It may well happen, and if it does happen, then the law will ensure that the child remains the child of the surrogate mother.
Single parents can apply under certain conditions. What are these?
Well, basically, I don't see why there should be any difference between, and maybe this is quite a liberal point of view, but I don't see why there should be any difference between a couple or a single parent. There is no evidence that I've seen that suggests that a couple over single parents are any better or any worse. Of course, there are advantages to being a couple in that you can share responsibilities, you can share when you take your child to school, who picks up, who does what. So obviously we understand logistically and in the day-to-day what are the advantages of having more than one parent. But in my view, it would have been grossly unfair and indeed discriminatory to allow for surrogacy arrangements to take place with couples, but for surrogacy arrangements not to take place when a person is not in a relationship. And if I recall correctly, the addition to the UK law to allow for single parents to be able to become a surrogate parent was introduced recently, certainly within the last few years. But it wouldn't have, I wouldn't have needed for the UK to change the law. Certainly from the very beginning, my view has always been that if you allow surrogacy arrangements for couples, you also have to allow it for single people.